Hello everyone, welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, big fireworks today in the Kyle Rittenhouse trial. Now, if you haven't been watching the news yet or you're just getting to it right now, Mr. Rittenhouse took the stand today. So is that where all the big fireworks came from? No, actually, we're going to talk about where that came from and what it tells us about how this trial is going for the prosecution. So let's spend a few more minutes tonight talking about what the Kyle Rittenhouse trial continues to teach us about the lawful use of lethal force. Okay, before we get too far down that road, if you like the video, go ahead and click the like button down below. If you want to stay up to date on issues related to your Second Amendment rights, go ahead and click the subscribe button down below. Click the little bell logo if you want to be notified if we post new videos. And most importantly, let's keep the comments and discussions coming, especially about this issue. It is a transitory issue. It's not going to last forever. So let's keep the comments and discussions coming because that's how we're going to get our videos out to more lawful and responsible gun owners like yourself. Okay, so as the headlines, as the mainstream media continues to report this case in a manner that I don't think is particularly accurate, but I digress. The big news today is the fact that Mr. Rittenhouse took the witness stand and candidly did quite well under pretty intense cross-examination. Now, that's intense cross-examination by way of a prosecutor. And the truth of the matter is, when it comes to trial lawyers, defense attorneys have a tendency to be far better at cross-examination because that is how we examine literally every witness. Prosecutors have a tendency to be far better at direct examination because that is how they typically will examine witnesses. But while Mr. Rittenhouse withstood the cross-examination, it was the judge who didn't like some of what was going on. So without further ado, let's roll some of the highlights today.
I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
Yes. And you'd agree with me that you're not allowed to use deadly force to protect property, correct?
Yes.
But yet you have previously indicated that you wished you had your AR-15 to protect someone's property, correct?
I'm going to ask you to go into the library again for a moment, please. Please don't talk about the case.
Mr. Premier is either forgetting court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an experienced attorney, and he knows better.
Mr. Baird?
First of all, Your Honor, this was the subject of a motion. I am well aware of that. And the court left the door open.
For me, not for you.
My understanding of
you should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
Because in my mind, and I argue this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
The defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car, on the car source lot. Now, there's no justification that I can think of why the defendant would point that gun at someone. The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he said, he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record if I could, without being interrupted, if that's okay. I am attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property. It goes,
He had the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is.
May I respond to what you just said, Your Honor? I'd like to respond to what you just said. I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay. So I'm attempting to impeach the defendant on his beliefs. I believe I'm entitled to impeach the defendant on his beliefs and on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call
his statements to, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property.
Your Honor, the court has seen no reason to change its ruling. And just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's prior reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop. And he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the
Don't
defense testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. But I don't see the similarity. I said it couldn't come in, and it isn't coming in. No matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Okay, so the big bone of contention today between the prosecution and the defense is the defense had successfully made an argument prior to trial in what we call a motion in limine. And motion in limine is a fancy term for we're going to argue about the admissibility of evidence before anyone actually tries to admit the evidence so as it not get mentioned to a jury, because as we say in the courtroom, you can't unring that bell. There had been a motion in limine that the reasons for Mr. Rittenhouse going down to Kenosha, Wisconsin, and some of his motivations for being there was not relevant to whether or not he faced imminent threat of death or serious bodily injury at the time. The prosecution, who we know yesterday, had an extremely poor day. It was about as bad of a day as it possibly could have gotten for the prosecution, and many were already surmising that this case was already over. Some have suggested by the actions of the prosecutor today in almost willfully violating some of the motions in limine and really pressing into areas in cross-examination, as the judge himself said, are not areas where we get to go. Are they actually trying to create a mistrial? And so you're hearing some discussion tonight about mistrial. What exactly is a mistrial? Well, a mistrial can occur multiple different ways. The most common way that we get mistrials is that a jury is deadlocked. That is, a jury of 12 in a felony or 6 in a misdemeanor are unable to reach a unanimous decision. And no matter how long they deliberate, they come to the conclusion that we will never reach a unanimous decision. In that case, the court could declare a mistrial and the state would have the option of retrying the case. Double jeopardy would not attach at such point because the person first trial had been declared a mistrial. That's the most common way. Now, another way that we see mistrials is occasionally through juror misconduct, and that's one of the reasons we pick alternate jurors, so that if we do have to excuse a juror, as what happened in this case for juror misconduct, we have alternatives that have been sitting in there, alternates that have been sitting in there all along, and can just basically step into that seat and replace the original juror. Occasionally, though, we will get mistrials because one side or the other absolutely violates previous motions in limine or so grotesquely violates the rules of evidence as to allow evidence or comments to be made in front of a jury that has then so tainted the jury that they no longer can fairly decide the case. And in that situation, a judge could declare a mistrial. Is it possible that the prosecution is actually trying to get a mistrial here, recognizing that their case has completely fallen apart on them in the last 48 hours? It is possible. I don't know what the probability of that is, because candidly, that would border on unethical behavior. And one of the things you need to understand is while every lawyer has rules of professional conduct that we must follow, there is an entire separate section that prosecutors must follow in addition to all the regular rules. Now, something else we're learning about this case is when it comes to trial work, trying a case is really telling a story. And the side that tells the most believable story is the side that will usually prevail. Now, the most believable storyteller is oftentimes the most likable of the attorneys in the courtroom. And with all due respect to the prosecution here, who I think is trying as hard as they can with not a lot of evidence to work with, the smugness of this particular prosecutor, the arrogance of this particular prosecutor, would not play well with the jury. Now, this argument has taken place outside the presence of a jury. They've been excused so that they can have these legal arguments. And certainly the judge and the tone and he's using with the prosecutor not only demonstrates the frustration that he has with him or the ongoing frustration, but really begins to demonstrate the level and severity of some of the violations or the envelope that he is pushing. If he has the same attitude in front of a jury, I don't see how any person could like this individual, trust this individual, and believe in the story that they're saying. So what's the bottom line? What can we learn about this today? Well, we know a few things. Number one, we know, according to law here in Washington State, that lethal force cannot be used unless a person is in imminent threat of death or serious bodily injury. What else do we know? Well, we know in Washington State, we are under no duty to retreat. That is, as long as we're lawfully located in a place, we're under no duty to retreat and can stand our ground and defend ourselves and use lethal force if necessary. That is, that we're in imminent threat of death or serious bodily injury. The state of Wisconsin, however, does not have a no duty to retreat or a stand your ground provision. As a matter of fact, the law in Wisconsin allows a trier of fact to consider retreat as an alternative when determining the necessity of the force that was used. What the prosecution is trying to do here is to take events that far preceded the actual events that are relevant to this trial and put in the mind of a jurors that Mr. Rittenhouse was engaged in vigilante justice and went down there looking for a reason to shoot somebody. Now, while I know this point has been debated by many, and while I think that's great for the court of a public opinion, when we are in the court of law, we need to focus on what the law requires. And in this situation, Mr. Rittenhouse will be judged on the necessity of his force and analyzed under his ability to retreat. Certainly, when we take a look at the videos and we realize how he had been knocked to the ground and was being surrounded by people, the ability or duty to retreat, the ability to flee the scene was significantly diminished. We also know that the one surviving victim has already admitted under oath that he pointed a firearm at Mr. Rittenhouse before Mr. Rittenhouse fired upon him. But ultimately, what this really has shown us today is that the prosecution's case has completely crumbled, that they recognize that they are behind the eight ball, and that they in all likelihood are going to suffer a rather humiliating defeat. At this point, they are literally grasping for straws. This is a bunch of Hail Mary passes, and they're hoping somehow or another they can get back in the ball game. Candidly, I think the work of the defense counsel has been quite excellent in this case, and they are clearly trying circles around the prosecution. Listen, you may have more questions about the Kyle Rittenhouse case or anything related to your Second Amendment rights, and if you do, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Listen, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.